Hello, Leslie Ann. We can see you.
Thank you.
We're going to go live in a few seconds. So let's switch our videos off and then we'll then turn them back on when the panel starts. Thank you. Good morning, good afternoon, and good evening, everyone. Welcome to this session. I am Ilaria Bottigliero, Director of Research and Learning at IDLO. A very warm welcome to today's event on elimination of discriminatory laws, accelerating action for gender equality, an event organized by IDLO and UN Women, with the support of the Philippine Commission on Women in commemoration of International Women's Day. On your screen, we will now put a few housekeeping rules for our webinar today. Please note that our session will be recorded, that the chat is open, and that we look forward to an active discussion during our Q&A time. So feel free to send your questions using the Q&A function right after the panel discussion. And now it is my distinct pleasure to share with you some inspiring remarks which we received by video from IDLO's Director General Jan Beagle and from Assistant Secretary General and Deputy Executive Director of UN Women, Anita Bhatia. They will frame our discussion today and will invite us to reflect on some important points. Let's hear from Director General Jan Beagle.
I'm pleased to open today's event on eliminating discriminatory laws. This year's theme for International Women's Day, Gender Equality Today for a Sustainable Tomorrow, celebrates the contributions of women and girls to climate change adaptation and response towards a more sustainable future for all. Climate change, COVID-19, and multiple global crises are exacerbating poverty and other drivers of gender inequality. It is clearer than ever that advancing the rights of women and girls against the backdrop of these systemic threats will be one of the great challenges of the 21st century. IDLO is the only global intergovernmental organization exclusively devoted to promoting the rule of law to advance peace and sustainable development. Gender equality is at the core of our mandate. Through our programs, research, and policy advocacy, we champion equitable legal reform as a critical enabler of the empowerment of women and girls. There has been significant progress, with numerous countries introducing reforms or amending laws. However, legal equality is far from being achieved. Discrimination in law is a serious concern because it both drives and normalizes gender inequality and aggravates existing inequities for women and girls across every sphere. The disparities they face are inscribed in the statute books. On average, women have only 3/4 of the legal rights afforded to men. Almost 100 countries do not legally provide for equal remuneration for work of equal value. Daughters cannot inherit in the same way as their brothers. Widows cannot inherit in the same way as widowers. Many women cannot legally head their households. And existing protections fail to prevent child marriage, which impacts approximately 12 million girls each year. Recognizing the urgent need to identify and reverse discriminatory laws, IDLO is working with UN Women and national partners to undertake comprehensive reviews of legislation in several countries. Allow me to share 5 points drawing on our experience. First, it is critical to invest in comprehensive assessments of legal frameworks. These reviews can lead to new laws or the repeal of discriminatory ones. They also help uncover potential blind spots in areas not conventionally seen as impacting women's rights, such as commercial law or climate adaptation. Second, successful legal reform requires close collaboration with the institutions capable of spearheading legislative change, including ministries of justice, law reform commissions, judiciaries, and parliaments. Third, we must support civil society, especially women's rights advocates, who play a key role in advancing legal reform through monitoring, capacity development, strategic litigation, and advocacy. Fourth, legal reform must be coupled with equality and access to justice, whether through formal or informal justice systems. Without effective access to justice, women's rights commitments will remain only promises on paper. Lastly, partnerships are key to accelerating action towards the adoption and enforcement of gender-responsive laws. I would like to thank UN Women and Executive Director Seema Bahus for our long-standing partnership, including on the elimination of discriminatory laws worldwide. We are working together to implement the Equality in Law for Women and Girls by 2030 strategy, which aims to fast-track the repeal of discriminatory laws in 100 countries and seeks to address the legal needs of over 50 million women and girls. I would also like to thank our partners in the Philippines and Sierra Leone for their invaluable contributions to the 2 legal assessments being launched today. Equality under the law is a prerequisite for gender equality. Let us renew our efforts to battle discrimination in all its forms and ensure lasting reform in the legal status of women and girls everywhere.
Thank you so much, Director General Jan Vigo, for your inspiring remarks. And it is now my pleasure to hear from UN Women Deputy Executive Director Anita Bhatia.
Excellencies, distinguished participants, it is a pleasure to address you today as we continue the celebrations of International Women's Day. Gaps in the law, as well as laws which discriminate against women, are one of the most persistent and continued causes of gender inequality. And while there has been a great deal of progress in this area in recent times, gaps still remain. Important advances have been made in reforming constitutions, especially to include standalone clauses that address the vital issues of women's rights, women's political representation, and sexual and reproductive rights. But we still have a long way to go. According to UN Women's recent estimates, 3.7 million women and girls are currently living in countries where discriminatory laws are in place or key protections are lacking. And we know that while 192 constitutions guarantee gender equality and non-discrimination, 12 constitutions do not apply the guarantees in matters of adoption, marriage, divorce, and inheritance. Of the 44 constitutional monarchies in existence, 27 are strictly patriarchal. In many countries, legal protections have been put in place to ensure gender equality in the workplace, but equal pay legislation is still lacking. Several fields, such as equality in parenthood, as well as efforts to address child marriage, are areas where much more needs to be done. In 2021, contrary to international commitments, the legal standard in 146 countries still falls short of 18 years of age, without exception, for girls and also for men and women in line with international standards. That, ladies and gentlemen, is too big a gap. Furthermore, over 30 countries still lack laws prohibiting domestic violence, and in an estimated 18 countries exempt perpetrators from prosecution from rape if they marry the survivor. This is unacceptable. These are just a few examples of de jure discrimination that women face. Addressing inequality before the law requires a multi-stakeholder effort. That is why we are delighted that UN Women is working with IDLO and other parties in the implementation of Equality in Law for Women and Girls by 2030, a multi-stakeholder strategy for accelerated action. Based on our experience on the ground, we know that it is actually possible to change discriminatory laws. In the past 10 years, UN Women has provided expertise and support to governments in 89 countries and has impacted an estimated 3 billion women and girls. UN Women country offices have pursued several strategies to advance legal reforms. These have included undertaking comprehensive reviews of national legislation and their applicability to international and regional standards. The results of this effort in Ethiopia, the Philippines, and Sierra Leone have brought us together today. We are extremely proud to have undertaken these three important exercises in partnership along with IDLO, and we are looking forward to participating and replicating this work in other countries. The next step is now for the three countries to implement the recommendations of the report, and the core of this is to actually address the gaps in the law of the sorts that I alluded to previously. We look forward to hearing from our distinguished speakers from these countries on how these reports will be translated into action-based roadmaps for reform that have a real impact on the lives of women and girls. Thank you.
Thank you very much, Deputy Executive Director Anita Bhatia, for your encouraging words. From these messages, it is clear that as we celebrate our achievements in many aspects of gender equality and women's empowerment, we should also be mindful that inequality in law continues to persist, and that legal gaps have clear and direct implications on women's human rights, whether it is in marriage and family life, employment, health, education, sexual and reproductive rights, the use of land and natural resources, political participation, just to mention some. Today, we will look at some of the persisting challenges that prevent women from being treated equally under the law, but we will also try to identify so-called pathways and practical solutions to ensure that not only discriminatory laws are eliminated, but also that countries move towards the adoption of gender-responsive laws. As part of the discussion, we are really pleased to share with you today the results of some of the work we have conducted in three countries, Ethiopia, Philippines, and Sierra Leone, to ensure that we are moving in the right direction in terms of eliminating laws that discriminate against women and girls. As mentioned by our Director Generals, this work is part of the global strategy on equality in law for women and girls by 2030, a multi-stakeholder strategy for accelerated action. And today we have actually released the legal assessment conducted in the Philippines by IDLO, UN Women, and our national partner, the Philippine Commission on Women. In the coming days, we will also release legal assessments on Sierra Leone and Ethiopia. It is therefore a great pleasure to have with us today some of our local partners who will share with us some special remarks. So let me introduce you to the speakers who are with us today for the special remarks session. Ms. Sandra Montano, who is the chairperson of the Philippine Commission on Women. And also we have with us Commissioner Meskerem Geset Techane, the Commissioner for Women and Children's Rights of the Human Rights Commission of Ethiopia. Let's start with a video intervention from Ms. Sandra Montano, the chairperson of the Philippine Commission on Women. Please.
It is with great pleasure, as a chairperson of the Philippine Commission on Women, to greet all the participants and esteemed guests of this momentous event in celebration of International Women's Day, a pleasant day, and happy Women's Month. The celebration of Women's Month is among a number of laws in the Philippines that promote women's empowerment. As a woman and a public servant, I take much pride in our landmark legislations for women, such as the Women in Development and Nation Building Act, anti-sexual harassment, anti-rape, anti-trafficking in persons, anti-violence against women and their children, the Magna Carta of Women, the Responsible Parenthood and Reproductive Health Law, the Expanded Maternity Leave Law, and the Safe Spaces Act. It is also my honor to inform you that before the year 2021 ended, the Philippines passed a law that prohibits child marriage through the passage of Republic Act number 11596. This landmark legislation protects the rights of girl children and helps ensure that they'll be able to reach their full potential. These laws that I have mentioned were products of decades of sweat, blood, and tears of women and gender equality advocates. There were times when everything seemed to be on the dead end. Yet, fellow women and gender and development champions and advocates never gave up, but pushed until they made victories and important milestones, further strengthening the gender equality and women empowerment in the country. That is why I would like to highlight the importance of convergence and collaboration between and among civil society organizations and the government. Collaborative efforts have really been instrumental in making the impossible possible, especially for women. Indeed, with CSOs and women's organizations support initiatives, we were able to develop and pass laws to help eliminate discriminatory laws against women and girls, although much still needs to be done. There are still discriminatory provisions in some of our existing laws, and discrimination, exploitation, and violence against women still happen. We still need to repeal or amend discriminatory provisions of the antiquated Revised Penal Code, Family Code, Code of Muslim Personal Law, pass a law that provides protection to Filipinos with diverse sexual orientation and gender identity, or SOGI, among others. In reality, the bottleneck lies in the prevailing patriarchal and macho mindset of some legislators. It is definitely a challenging impediment that prevents us from further pushing the women's priority legislative agenda. Another challenge to note is in the reporting, monitoring, and implementation of these laws. Implementing agencies need to ensure that a monitoring and evaluation system is in place. It will really be a big waste if these laws will not be felt by ordinary women and girls down to the grassroots level. Likewise, both legislative chambers, the House of Representatives, and the Senate should really maximize their role as oversight in reviewing the effectiveness of the laws. This is really a crucial opportunity for stakeholders to engage in reviewing the effectiveness of the existing laws. I really believe that the process of passing a law is just part of the whole pie. Implementing, monitoring, and assessing the effectiveness of the law form the other half and should be taken into consideration. That is why we in PCW really welcome and appreciate the legal analysis study report because it provides us with the legal basis and context of why we need gender-responsive legislation to address persistent and emerging women's gender issues and concerns. The inputs and recommendations in the legal analysis also provide clear suggestions and directions in our advocacy and on what and how to revise, amend, or repeal existing discriminatory laws if not develop and propose new legislative measures. Moving forward, the PCW is already in its final stretch in preparing the Women's Priority Legislative Agenda for the 19th Congress. We hope to launch it on the third quarter of the year after the national elections. As PCW chairperson, I would like to take this opportunity to propose to IDLO and to UN Women Philippines to come up with initiatives to engage incoming legislators and their staff and capacitate them on how to be gender responsive in formulating proposed legislative measures and instill in them the importance of integrating gender perspective in the legislative meal. We hope that we can work together on this and educate our legislators, their staff, and even local board members who also develop policies at the local government level. Rest assured that we welcome further collaboration with you, our partners, towards achieving our common goal of eliminating discriminatory laws. I congratulate the whole team for this document. Again, happy Women's Month!
Thank you so much, Ms. Sandra Sanchez Montano, Chairperson of the Philippine Commission on Women. I know that you are connected and together with many members and colleagues of the Philippine Commission of Women. So I would like to thank you personally and your colleagues for being such great partners of this project of IDLO, UN Women. And thank you so much for moving the project forward and for moving so fast into implementation, as you mentioned in your remarks. So now let's hear from Commissioner Mesqueren Geset-Techane, from the Commissioner for Women and Children's Rights of the Human Rights Commission in Ethiopia. She's also a current member and former chair of the UN Working Group on Discrimination Against Women and Girls. So let's see if we can get Commissioner Mesqueren Geset-Techane live. Yes, so the floor is yours, Commissioner, please.
Thank you so much. Good morning, good afternoon, good evening to all. Warm greetings from Addis Ababa, Ethiopia. It's my pleasure to join you this afternoon in my time, and I really thank UN Women and the IDLO team for bringing us together to discuss this important and interesting topic. If you don't mind, I might, if the video is breaking, I can also put it off, but so far it looks so good. So ending discrimination in law, eliminating discriminatory laws is an important process for achieving gender equality, as we all know. But we also understand that it is only the start, not the end. We all understand the potential of equality in law in catalyzing the de facto equality for women and girls. I will move to the practical points that how do we bring about the end of discriminatory laws from a practical point of view in our experience. But first and foremost, we highlight the importance of commitment at all levels to eliminate discriminatory laws. Commitment at political level, commitment at community level, and also commitment of all activist forces activist forces or catalyst forces like the civil society, like national institutions like ours, and also other women and girl activists at the grassroots level. And this needs to be complemented by capacity and also attitude or awareness to really realize the transformative potential of laws to bring equality in practice. And continuity of this commitment, continuity of the capacity building for a gender responsive legal reform, and continuity of awareness and attitudes is also important, as both forms of discrimination as well as our understanding of discrimination evolves. As an entry point to move to a more practical discussion, what we have seen as entry points for ensuring political will, first is the integration of gender as a central point in all legal reform or legal review process or lawmaking process. We have seen in some efforts having gender dimension at the center of lawmaking or legal reform has really a potential in bringing more gender equal laws. For this, gender analysis of laws is an important step to have trained legal staff or legal drafting team that has a gender, that brings the gender perspective into the legal reform process, and also a trained parliament that understands the importance of gender responsive laws, and also equipped civil society actors who also push from outside to bring the repeal of discriminatory laws, as well as adopting positive laws that introduce positive measures towards gender equality. So bringing it all together into a more coordinated approach towards legal reform or lawmaking is one entry point that we have seen to ensure political will for just elimination of discriminatory laws. And more practically also integrating into the human rights obligation of states. As you know, many states at this stage are party to a number of important international human rights instruments, from CEDAW, CRC, to also the regional ones in the African context. For example, the African Human Rights Charter, the Maputo Protocol on the rights of women, on the rights of children, older persons. I mean, the list is long, and trying to integrate as part of the state's obligation to deliver on this international instrument is an approach to ensure political will that we have seen worked in the past. And also, again, integration in the national SDGs action plan or other development plans has also worked in ensuring political will, or at least pushing the boundary towards ensuring political will. Again, human rights action plans are very instrumental in having the rights of women as pillars in the implementation of national human rights action plan, both as a standalone objective and also integrating or expanding throughout all the other pillars in the national human rights action plans. Moving to positive approach, building on this entry points, we have seen comprehensive legal reform being initiated in the Ethiopian context since 2018. And that's the time where the government launched a comprehensive legal review process following the political reform, which has offered actually opportunities for inclusion of gender equality, the rights of women, both in terms of women's representation as well as in terms of also substantive aspects of gender equality and elimination of discrimination. We have seen electoral laws, criminal procedure, media laws, civil society laws, and other laws being reformed, including also the establishment of the proclamation establishing the Ethiopian Human Rights Commission, our commission. And all these laws brought their positive contribution towards the elimination of discriminatory laws by ensuring the representation of women in institutions and processes, and also the representation of women's interests in all these laws. And In relation to this, we have also the reform of institutions like the National Electoral Board, the Ethiopian Human Rights Commission, and others, which are actually on the forefront of ensuring women's participation in leadership and also the inclusion of women's rights in all their work. I'm proud to report that our commission is currently engaging in comprehensive legal review on the rights of women to see the compliance of national laws with international standards, which actually builds on the assessment that's done by the UN Women, which we are launching today or this week. So we aim to build on this assessment by also expanding to policy framework and also by expanding to other regional state laws, because Ethiopia has a federal arrangement. We feel that it's also good to analyze all the other laws that are parallelly operating at the federal and regional level. Another promising practice I would like to also share is also an initiative by the Ministry of Justice on gender analysis of laws, which actually builds on the UN Women assessment, because the ministry was a partner during the assessment. And now there is this initiative to look into the institutional or organizational capacity, process, and working methods, as the ministry is the lead advisor to the government when it comes to legal drafting. And there is also an initiative for training the legal drafting team to become more gender sensitive. And this also comes together also in integrating into the National Human Rights Action Plan, which I've mentioned earlier. Another very good promising approach to take into account in our context is also the role of the parliament or the Parliament Women Caucus, which is hoped to be championing gender responsive laws within the parliament. Ethiopia has a women's parliament caucus in the past that had an instrumental role. And now we have this new parliament caucus established following the establishment of the new government after the 2021 election. And we hope that this caucus is also the insider ally within the parliament to champion gender responsive laws. We have now also new opportunities presented to us. We are in the middle of discussing national dialogue, peace building efforts, and also post-conflict reconstruction as we are hoping to come out of the conflict context and moving into a national consensus building process. And this all also brings an opportunity for us again to raise the agenda of elimination of discriminatory laws, which also would be part of the dialogue and also the reform process. And also again, an opportunity for pushing towards the representation of women in leadership and set the agenda for all legal and institutional reform process, which we hope also would have a great impact on the elimination of discriminatory laws at different levels. I would like to end here. Of course, there are challenges, still capacity, political will, still, we need to push the boundaries. We still are we have a male-dominated political system, legal system, and then the attitude, the understanding of discrimination and gender equality is still something that we have to work on. There is this missing point about the whole gender question, the whole gender equality question, and then issues about discrimination. Again, in our specific context also, we have, of course, challenge when it comes to implementing and monitoring the good laws that we already have. And then now we're currently also in the middle of political tension and just coming out of conflict. We have also competing interests that really divert attention and that really divide the political will. And some people don't even understand this conflict context affects women, and then it's also about gender equality and discriminatory laws. But we hope that our commission and also other actors, we hope to push for a more gender equal legal system, political system, and all these challenges. Also, we hope to turn them into opportunities. They are still entry points for us to advance the agenda for ending discriminatory laws. Yes, we are a long way, but we hope that we can work together with UN Women, IDLO, and all other international and national actors. And we welcome all forms of collaboration towards this common agenda. And thank you.
Thank you so much. Thank you, Commissioner. Thank you for your partnership, of course, for your work and for your efforts, despite the challenges that you highlighted very clearly, to ensure that women are not discriminated under the law, and also to ensure that they're equally represented in political processes and they express their leadership in all aspects. I would also like to acknowledge that there is a third legal assessment report on Sierra Leone on strengthening gender equality in law. This report was also developed by UN Women and IDLO in partnership with the Attorney General's Office and the Ministry of Justice of Sierra Leone. And its publication is expected to be released very, very soon. So we will also look forward to reading the Sierra Leone report. Now, before moving to our reflection panel discussion, for which we have a series of very distinguished speakers, I would also like to acknowledge that in addition to celebrating International Women's Day a couple of days ago, today is also the first International Day of Women Judges. So greetings to all of the women judges who are connected to this event today, but also to all women justice administrators, those who work really to administer justice in a fair and non-discriminatory manner. We really believe that your work is an essential part of achieving gender equality. So happy International Day of Women Judges, everyone. And it is now my pleasure to move to the panel discussion, our reflections, during which we will reflect on a few key questions that have been already touched on by our previous speakers. In particular, we would like to reflect a little bit more in depth on how do we bring about the end of discriminatory laws. So what are the promising approaches and the practical entry points to achieve this big goal of eliminating discriminatory laws, and in turn to achieve gender equality in law and in practice. But also we would like to reflect on the challenges. We have heard from our speakers that there are still very persisting and entrenched challenges in expanding political will, in supporting gender responsive legal reforms. So we would like to understand from our speakers their perspectives on these particular critical points. And for the panel, we have a wonderful group of distinguished speakers. You see them now also on video. Thank you so much for joining us today. They will help us navigate these difficult issues, and they will provide us their perspectives on how we can bring about change. So let me introduce you to the panel before giving them the floor. We have with us today Ms. Melissa Upreti, who is the chair of the UN Working Group on Discrimination Against Women and Girls. Hello, Melissa, welcome to the panel. We also are very happy to have with us Dr. Leslie Ann Foster, the Executive Director of the Massimaniane Women's Center and also the chairperson of the Gender-Based Violence Committee at the South African Women Lawyers Association. Hello, Dr. Leslie Ann.
Hello.
Good to have you on the panel.
Thank you. Thank you.
We also have with us Ms. Antonia Kirkland, the Global Lead for Legal Equality and Access to Justice at Equality Now. Hello, Antonia. Nice to have you on the panel today. And welcome also Ms. Elisa Scalise, the Executive Director of Resource Equity. A pleasure to have you on the panel, Elisa. Welcome. So welcome everyone. We will start with Melissa. Melissa, you are the chair of the UN Working Group on Discrimination Against Women and Girls. So from your perspective, from the perspective of your mandate as well, can you tell us a little bit more about challenges as well as promising practices on eliminating discriminatory laws and achieving gender equality through that? Thank you very much, Melissa. The floor is yours.
Thank you, Ilaria, and good afternoon, good evening, good morning to everyone on this webinar today. I'm very pleased to be part of this collective reflection on the elimination of discriminatory laws on behalf of the UN Working Group on Discrimination Against Women and Girls, which is a special procedure of the Human Rights Council. In the few minutes that I have, I'm going to touch upon some of the challenges that we see in our work as a mandate in very broad strokes. Of course, there are many, and the previous speakers have reflected on many of them. But the ones that we see that really stand out from a global perspective, but are also impacting efforts to address discrimination locally are, first of all, I'll highlight, well, the persistence of global discriminatory cultural construction of gender. I mean, this is often tied to religion and the continued reliance of states on cultural justifications for permitting discrimination, and even sometimes for adopting new discriminatory laws is problematic. Now, we know that the internalization of these norms often begins at a very early age, which almost guarantees their perpetuation unless they are challenged. But then those who do challenge them are often denounced, isolated, and subjected to violence. In other words, they face backlash. Now, we have repeatedly emphasized that the failure to eliminate discrimination within the family does undermine attempts to ensure gender equality in all areas of women's lives. Although discriminatory laws governing family life have been repealed in some countries, in fact, no country has eliminated all laws that discriminate against women. So this is the first challenge. Now, next, women are not a monolithic group, and they continue to face multiple layers of structural disadvantage and discrimination in the economic and social spheres throughout their life cycle. And the underlying cultural, social, and political causes of economic inequality have not been adequately tackled. For instance, a cultural construction of gender is used to impose a host of care responsibilities on women and girls, and this is a burden which, as a result of not being duly recognized, reduced, regulated, or redistributed at a societal level and addressed in economic policy, has become unbearable and unsustainable for many. Not to mention, it has increased relatively more for women since the onset of the pandemic. For millions, the entire situation is aggravated by the denial of reproductive autonomy and pervasive violence, which can be linked back to discriminatory laws and policy, the absence of legal protections, and harmful gender stereotyping. This suggests the existence of a vicious cycle. This leads to my next point. We have observed in our work that women's sexual and reproductive rights are particularly under attack. In some countries, women live under threat of criminal punishment for sexual or reproductive conduct guided by their own choices, while cases of sexual and reproductive violence perpetrated against them frequently go unpunished. The criminalization of abortion is one of the most damaging manifestations of the instrumentalization of women's bodies, subjecting them to unnecessary risks and fatalities and depriving them of their autonomy and, in many instances, their liberty. An additional challenge is that globally, women remain underrepresented in political and public life. We have repeatedly expressed concern about the dangers faced by women human rights defenders around the world, which is driven by deep-rooted discrimination against women and a desire by those who hold power to maintain the status quo. This leads to my next point, which is that regression, led by conservative right-wing actors, fundamentalists, and those opposed to gender equality, has intensified in many parts of the world. And this is another major challenge. How do we ensure progress towards eliminating discrimination against women while simultaneously fighting against regression led by or undertaken with the direct involvement of states and powerful non-state actors? At the end of the day, since it is states which hold the power and the necessary resources to transform entire systems, we need to see a significant increase in the political will of states to invest time and resources in the formulation and implementation of laws, taking a rights-based, intersectional, and multidisciplinary approach. It is very important to remember that formulating new laws to function within systems that have historically and continue to systematically perpetuate disadvantage and inequality are not likely to be effective. The truth is that our current systems and institutions must be simultaneously redesigned and rebuilt based on equal power relations and with the participation of women, the law reform to actually have the desired impact. As I conclude, I'd like to emphasize that ending discrimination is not optional to states, but it is a core obligation, and we must do everything we can to hold them to account. The elimination of discrimination against women and girls, who are half the world's population, must be a central component of every legal and policy framework and decision, because every issue has a gendered dimension and impact. The evidence shows that gender equality has increased, especially since the onset of COVID. We cannot wait for another 136 years to fill the gender gap. We have to accelerate progress. And we can do this by strengthening cooperation among states, women's human rights mechanisms, UN agencies, and feminist movements for whom eliminating discrimination is a priority, and by remaining committed to human rights. Thank you. Back to you, Elisa.
Thank you. Thank you so much, Melissa. And thank you for sketching this broader picture for us. The existence of economic, cultural, social discrimination, the deep root causes of discrimination is something that we must not ignore. And obviously, it's not just a question of amending a law, repealing a law. There are so much more to be done at the root of the problem. But you also end up with a very practical point, saying that the elimination of discrimination, the end of discrimination, is not an option. It's an obligation. It's our right and duty at the same time. So we must all work towards that. We have no other option that moving in that direction. So we are very encouraged by your words and very grateful for the work that you and the committee are doing for achieving this this goal that is so important, although sometimes it looks so far away from us. Dr. Leslie Ann, the floor is yours. Tell us, please, a little bit about how, in your perspective, we can accelerate action to eliminate discriminatory laws, especially in your local context. Thank you.
Thank you so very much. Your Excellencies, honored guests here today. It's a great privilege for me, and I'd like to thank IDLO and UN Women for the privilege of addressing you. I work at the grassroots level across several countries in Africa, and so I'm going to speak from that perspective, but also from our own perspective in South Africa. I think because it is, the period when we commemorate International Women's Day, I would like to commend everybody on this panel for the amazing work that has transpired. If we look back 30 years, we can see that there's been tremendous progress that has been made, and we've certainly deepened our analysis and our understanding of inequality and of how women are experiencing discrimination. In South Africa, we've just emerged from the heinous apartheid era, which was such a horrific state that we lived through for many years and many decades. And with the liberation, we were so excited to, of course, first start with putting in very strong and powerful gender machinery to address the inequality that women specifically faced. And we were revered for having the most progressive constitution in the world. It's still considered one of the best because it contains such a powerful Bill of Rights which women themselves were responsible for ensuring that it's contained in that in Constitution. And something else which is very powerful about the Constitution is that it guarantees the rights of all. However, some 26, 28 years down the line, what we have found is that there's not been enough change for women. There has been change. We've seen women take up decision-making positions. We've seen women's participation in parliament, in the political sphere increase. We've seen women take up major roles as head of the military and head of the South African Police Services. But what's the reality is that the majority of women remained mired in poverty, exacerbated by the COVID pandemic. And I think that what we are seeing here now also needs to be recognized within the larger geopolitical context, where our economic policies are determined external to our countries across Africa. And that's why we have the continued poverty. And COVID has certainly not contributed in any significant way to this. What we have seen as a country and as a region is that women have been at the forefront of changing policies and of actually highlighting the discrimination and the oppression that they faced. And we've done this through research, through strengthening our evidence base across several countries, being able to use that evidence at a national, regional, and international level. So that was one of the critical strategies that we used to highlight the discrimination that women faced. We've changed policies and we've tried to harmonize those with international law. We've tried to bring it in line with the precepts of the CEDAW Convention, Maputo Protocol, and other such instruments. We've used those to great effect. In some cases, that has helped us to change the policies and the laws in our country and to make them more responsive to women. However, what has happened over the last decade, I would say, is that we've seen a shift from what was a very strong gender focus to gender neutrality. And in May 2014, I think it was, the Special Rapporteur on Violence Against Women noted that in fact, the whole global community is moving towards gender neutrality and actually recycling patriarchy as a gender response. And this is very problematic, particularly in African societies. I think we have managed to get some laws in place that are helpful to women. What has been really powerful in South Africa is that women have used the courts to highlight the discrepancies in the law and to show how they discriminate against women. And we have some amazing legislation that was sent back to Parliament for review and for harmonizing with international standards. So women continue to push the process of getting the laws really closely looked at to ensure that they are gender responsive. What we've also found is that the problem is that there are so many different groups of women and so many forms of marginalization, and laws do not take an intersectional approach. They're a one size fits all. And that continues to be a challenge to women's organizations as to how do we get, if we have a law in place, for instance, we have a Domestic Violence Act, the way it works for women in urban areas as opposed to women in rural areas is very different. And that is a gap that we still, haven't quite overcome. Some of the things that we've been very successful in using, as I've said, is we've used the courts, we've used regional and international instruments to push perspectives on equality, and we've used shadow reporting, we've used different forms of different regional meetings and international meetings to actually bring to attention the challenge that we face. What I think is also a problem is that we've had a rise of the right wing globally, and we have not been exempt from that. And with the rise of the right wing, we've seen the regression in our laws and policies, in our gender machinery, the quiet closing down of certain committees that oversaw Parliament, in terms of how they passed laws and so forth. So we've often spoken about the closing of political spaces globally. This has been one of the ways at a national and regional level that we have seen this happening, the closing of spaces. We've also seen, a previous speaker has spoken quite a lot about the rise of nationalism, of fundamentalisms, of conservatism that comes through our religious and cultural institutions. And these have more weight at community and societal level than the laws of the land. And that gap between the laws which try in some ways to dismantle inequality and discrimination against women are then entrenched within those societal institutions. And there's a big problem that we continue to face around that. Some other positive developments have been the UN Gender Equality Forum. I don't know how that's playing out in other countries, but in South Africa and across Africa, we have embraced that. And the action coalitions to advance gender equality are working very, very strongly to use that mechanism as a way for getting these states to give greater political support to ending discrimination and to ensuring substantive equality for women and girls across the different countries. What we've also found very useful is working with young women. I need to say this because I think it's very important, and some speakers have spoken about this. The women's movement is critical in calling the state to account, especially on issues of inequality, of discrimination, of oppression. And it is young women that are showing themselves to be fearless, to be fierce, to be at the forefront of these battles and willing to challenge in ways that we've not thought possible. And it was interesting in having a conversation with young women where we were discussing the closing of political spaces, and they challenged us on that, saying, but these political spaces are actually open because of social media and the different platforms that we can work on now, where we have greater reach in terms of how we can get the messaging out there on what it is that we want. So I think that we need a top-down approach, but we also need a very strong and powerful bottom-up approach. And I want to say that educating communities about their rights, educating communities about how to hold the state accountable right from the local level to the national level is critical to us being able to advance gender equality in all of our societies. Thank you.
Thank you so much, Dr. Leslie Ann Foster, and thanks also for sharing with us how difficult it is from moving from law to practice, despite having a great constitution, very progressive. Then we see little change at the local level for women, or at least we do not see the change that we would like to see or we would expect. So thanks for bringing your perspective to the panel and to our audience. We have now with us Ms. Antonia Kirkland, who is a global lead for legal equality and access to justice at Equality Now. Antonia, it's a pleasure having you with us. Please let us know from your perspective, what are your feelings about eliminating discriminatory laws, challenges, good practices, solution, and what can your organization contribute to that? Thank you.
Thank you so much. Your Excellencies, IDLO and UN Women, thank you for allowing me this opportunity to speak about how together we can achieve equality in the law as a means to realizing gender equality. This is at the core of Equality Now's mission, and why I'm really proud that we are partners in UN Women's multi-stakeholder strategy for accelerated action. So we have also found that what is key to bringing about legal reform is mobilizing at all three levels: global, regional, and local. And I would like to illustrate this with the story of Noor in Jordan. One day, 20-year-old Noor, who worked for 55-year-old Abed at his mobile shop and in his home, was raped by him. As if this wasn't traumatic enough, her family and community pressured her into marrying him to remove the stigma they believed it placed on the family's honor. Her rapist escaped all punishment by marrying her, as this was explicitly allowed under Article 308 of the Jordanian Penal Code. For months, as his so-called wife, she endured more rapes, trauma, isolation, and anxiety. My only hope from marrying him was to make my baby safe, she said. I was keen to register him in his father's name. As the situation further deteriorated, he offered to recognize the baby while divorcing me. I accepted that because I could no longer bear living with my rapist. So working at all three levels, we and our partners were able to bring about the repeal of this law and similar ones in the MENA region. At the local level, using public art and advocacy, our partners galvanized civil society and fostered political will among feminist parliamentarians. At the international level, we worked with our partners to collect, collate, and submit evidence to UN treaty bodies, who then put pressure on the governments. And at the regional level, we convened activists and parliamentarians from across the region to learn from each other and strategize. And we garnered a lot of media attention. The result in 2017 and 2018, Jordan, Lebanon, Tunisia, Palestine, and also Malta all reformed these so-called marry your rapist laws. This type of feminist activism has been well evidenced, including in a 2020 European parliamentary study as an effective approach. But changes in law, as we know, are not enough. They must be backed up in practice, and including through the implementation and enforcement of judicial decisions. For example, the African Commission on Human and People's Rights decided a case in 2015 against the Ethiopian government for failing to protect a 13-year-old victim from 2 abductions, rapes, and a forced marriage, which at the time of the crime was explicitly allowed in the law. The remedies awarded in the decision must now be implemented. This includes explicitly prohibiting this practice by law and prosecuting offenders, nationwide judicial training, data collection on the prevalence of the practice, as well as compensation for the victim. Unfortunately, this practice is still going on today in many countries. In South Sudan, for example, although rape, abduction, and marriage are criminal offenses, customary law courts allow the perpetrator to avoid prosecution if he pays a dowry, thereby securing the victim as his wife. So another promising approach for reform, which other speakers have touched on and which seems obvious, is to elect more feminists to parliament and appoint them to positions of power. Not surprisingly, the World Bank's Women, Business, and the Law group has found a link between the number of women in parliament and legal equality. Conversely, for example, we've seen women only make up 3.6% of the MPs in Nigeria in the parliament, which very recently rejected all the pending bills on gender equality, including ones that would have eliminated discrimination in their nationality law. In Malaysia, another example, only 15% of MPs are women. And the Deputy Minister of Women and Family recently endorsed domestic violence as a solution for marital strife. The government of Malaysia is also appealing against a positive court decision, granting greater rights to women to transfer their nationality to their children, while saying at the same time that it intends to reform the Constitution to grant these women the same rights. And to further facilitate the elimination of discriminatory laws, we believe that governments must also no longer omit or block the most basic fundamental right of sex equality in their constitutions, the highest law of the land. The United States Department of Justice is currently in court fighting the certification and publication of the Equal Rights Amendment to the Constitution. And in Jordan, a physical brawl even broke out in the parliament in December during a vote on constitutional equality. So at Equality Now, we recognize that it takes a diversity of actors to bring about legal change. And for example, we recognize the essential role of faith-based actors in promoting gender equality within religious family law and civil law. And to achieve family law reform, we have joined forces with organizations like Musawa, Muslims for Progressive Values, ACT Church of Sweden, as well as UN Women and regional feminist organizations in a global campaign for equality and family law to put urgent pressure on the government to undertake reforms. Indeed, global coalitions are impactful, and we have seen this with the Global Campaign for Equal Nationality Rights, made up of global and national organizations, as well as UNHCR working together, have helped spur reform in this area of the law and secured government commitments to further reform through national level workshops, regional convenings and engagement at the League of Arab States, for example, and through international advocacy. But resourcing for such coalitions is sorely needed, however, to multiply their impact. And of course, global fora such as the UN Commission on the Status of Women, the High-Level Political Forum, the Generation Equality Forum, which the previous speaker mentioned, and the UN General Assembly are some key entry points for advocating for legal equality, in addition to engaging with the UN treaty bodies and special mechanisms, as mentioned before. And comprehensive legal assessments, such as IDLOs, do help raise awareness and inspire action, we hope, by governments to eliminate all remaining discrimination in their laws to get us ever closer to gender equality. Thank you.
Antonia, thank you. Thank you so much also for bringing this discussion to a very real point where we have concrete examples, where we see the repercussions of having discriminatory laws on the people, where we see how the absence of women in parliaments actually affects real women on in their daily life, whether this is through the absence of laws prohibiting rape or intimate partner violence or gender-based violence. So it becomes a question of life or death many times. So thank you for bringing your perspective to this panel. And we can now move to our last reflection panelist, last but not least, Ms. Elisa Scalise, the Executive Director of Resource Equity. Elisa, welcome to this discussion. It's a pleasure to have you here today. Tell us a little bit more about the importance of eliminating discriminatory laws, especially in the area of land and natural resources in economically poor countries, which is an area, a field of work which is so much affected by still patriarchal norms and legal frameworks. Elisa, the floor is yours.
Thank you, and thank you to the organisers of this event, and also I wanted to express my gratitude for being here and for being amongst such wonderful, thoughtful and brilliant minds, and it gives me a lot of hope for the future to be among you all. So thank you very much for the opportunity. At Resource Equity, we work on addressing discriminatory land and property laws and tenure systems, and they're not always included in the women's rights agenda, or they're kind of often to the side, yet they're really critical to gender equality in very real ways, in practical ways. And they're even more critical now, I think, or perhaps their crucial nature is underscored by the pressures that are the increasing pressures created by climate change and the responses to that around the world. A large part of the work that we do is working on laws, and we kind of do that in three ways. On one level, it's looking at creating and reforming formal laws so that they're equally responsive to the needs and lives of both women and men when it comes to land and resource rights, and addressing the systematic and historical discrimination against women for those rights. On the second level, because in many settings, land rights are governed by customs, and customary law can be more legitimate in the local settings, as another speaker mentioned. It's also about working within the customary legal systems on transforming gender relations with regard to land and natural resources. And third, as others have mentioned as well, looking at religious laws, because again, that's another source of property rights for women. And very often they are not, to the extent that there are protections for women within those systems, they come up against those same customary tenure systems as well, and often aren't enforced. But for today, we have limited time, so I'll just talk a little bit about some of the opportunities for action when looking at formal laws, and I'll just focus on three. The first is looking at laws that are discriminatory on their face. The second is laws that are discriminatory in their context or when read in context. And the third, looking at laws that are discriminatory as applied or administered. I hope you'll all forgive me for getting a little in the weeds. I won't go too deep in, but sometimes it can be helpful to kind of see technically how these things play out. And so we'll talk about them just a little bit. So looking at on the first level, laws that are discriminatory on their face, that seems quite straightforward. Change the law, things are okay. However, there can be discrimination in the way that laws are developed and the way that laws are created. And very often women, and I want to use women in quotes because there are many categories of women, but certain categories of women, say, are left out of the lawmaking process. And when women are left out of the lawmaking process, it's much more likely that the law won't reflect women's needs and preferences, which in my mind is a form of discrimination, because ultimately it prevents women from realizing their full potential and achieving and for achieving gender equality. So the first strategy is about meaningful inclusion of women at all levels, by that grassroots to all the way to the top and everyone across there, meaningfully engaged in the lawmaking process. The second thing I want to cover on is looking at laws that are discriminatory when read in context. And so I was glad that someone mentioned earlier about gender neutrality in laws and how that seems to be the way things are going. Yet we all know that there's no such thing as gender neutral laws because we don't live in a gender neutral society. And it's really important when reviewing laws to consider what they mean in that local context, because it's very often when read in context that the discrimination will be evident. An example of this is looking at marital property rights. Very often, most legal systems provide for some form of joint ownership of marital property between spouses, but a spouse is legally defined as those who are legally married. And in places where informal marriages or customary marriages are the norm, that excludes a whole subsection of society. So you can see how that in itself becomes a discriminatory law, even though on its face it would seem to be providing protections to married people. So a strategy there is to work with, this is a critical time when the expertise of local lawyers and local advocates is absolutely critical to understanding what the law means in the local context and how it's interpreted and how it should be read and how it will actually work in practice. And that's the best way that you're going to get to understanding and addressing gender unequal dynamics in households and in communities. And then the third is administrative law. This is probably the lowest administrative law, or perhaps I should say the lower level laws, regulations, decrees. These are the lower profile areas of legal reform, particularly when looking at gender equality and discrimination. And yet it's very often that in these laws, the rights that may be enshrined in other laws fall through the cracks. To be honest, most people glaze over when you talk about administrative law because it's not very exciting. But once again, you're dealing with an area where it's highly technical. They come across as technical laws as if there's no social implications to them. But in fact, there's plenty of opportunities for women to be discriminated in those settings. An example of that might be rules of evidence, where evidence that's required to prove a claim of right to land. That type of evidence is only available to men. And so that's a whole area where women could be excluded from asserting rights that they have in law, and then to not have them equally protected by the law. So a strategy for dealing with that is to pay particular attention to these lower level administrative laws and regulations and decrees, all those things that seek to operationalize the rights, and to ensure that those people who are perhaps on the technical side of administration of laws understand gender dynamics and understand how to address the systematic exclusion of women in many of these settings, particularly in with regard to land and resource rights. So in sum, if I may say, when considering discrimination in land and resource rights, it can be just as important to establish the rights or create the rights if they don't exist, as it can be to ensure that the rights endure, that they're protected when they're under threat, and promoted when there's any benefits to be gained from them. Thank you.
Thank you very much, Elisa. You really hit the point of making sure that when we're talking about laws and legal frameworks, we tackle not only the high-level frameworks. We've been talking about constitutions, we've been talking about laws, but the regulations, the bylaws, the details of our procedures, of our civil code procedures, criminal code procedures are in fact gender sensitive. So it is very important, because we know that on a daily basis, these are the mini norms that will be meaningful for women and will make a difference. So thank you for also raising issues about property laws and the intersection between formal and informal laws, which we haven't really discussed during this event, but I know it's an important component of discrimination against women and girls. Now, we are coming to the Q&A part of our discussion. So before moving to that, I would really like to thank our panelists for their initial reflections. But we have so many questions that I'm sure you will all be called on to expand on a few points. But thank you again for your important reflections. And also, I would like to take a moment to thank the chat, which is extremely active. So there are so many active discussions and very interesting points raised through the chat. So it's really nice to see that interaction, and let's keep it lively. I am receiving a lot of questions, so let me select a few of them for your follow-up. We have a friend from the Philippines, Mary, who is asking something about women in urban, poor, informal settlements, who by definition are considered illegal by virtue of their residence. And when they sell goods on the city streets, they are therefore considered illegal and sanctioned for that. How can laws protect rather than discriminate against them? We haven't been talking much about women in poor urban informal settlements, but this is a category who often is discriminated against by the law. So perhaps, Elisa, this is a question for you. If in 1 minute you can give us a quick reflection on how can the law protect this type of vulnerable, very vulnerable women.
That's a very good question, and I think it can be very easy to overlook sometimes the people who are discriminated against because of their status and because of the status of their housing and land and property kind of relates to that. So it's a very good and relevant question. I think one of the things when, unfortunately, I will say that actually there isn't a lot of very good attention on addressing informality in urban settlements. Even though with movements that's been made towards the urban agenda and things like that, there's not a lot of very good evidence out there and very little attention on it in terms of understanding what good practices are. So I don't know if I can give you a very complete answer, but I will say that as with in other settings, a critical piece to this is looking at protecting the constitutional rights that people have and understanding how they can be protected through various means, working with civil society actors to the extent that they exist to establish whatever it is that may be needed to to formalize the situation that those women are in. And by that, I mean, very often it can be a matter of having paperwork and documents and evidence and the types of things that they may not have accessible. So one thing to look at is either making those things available to women. There's been a number of successful interventions that actually work on that to help women gain access to those things that would help to formalize, if not all of their situation, at least parts of their situation. Or the other is to actually look at removing those barriers altogether and perhaps using other forms of evidence to be able to establish residency or whatever it is. So for example, it may be that you use witnesses or surrounding people or things that maybe are often not frowned upon by the legal establishment, but aren't really acceptable. But I think that actually we have to be creative when thinking about these things. And there's many things that can be locally valid and legitimate to help establish or formalize the situation of women in informal settlements that I think it's those pathways that we really need to be looking at. So
thanks, Elisa. Then Antonia, your intervention on intimate partner violence, rape, and the lack of remedies, and often the lack of adequate regulations on that triggered a lot of comments. So we have friends, especially from the Philippines, who are signaling that in many countries also the practice of pardoning the rapist is actually embedded in the penal codes. So they are asking what global efforts are there to address this, since there are so many countries that still embed this type of rules, discriminatory rules in their regulations and laws. Antonia, if you can, perhaps in 1 or 2 minutes.
Sure. I think one of the key strategies for highlighting the continuing existence of those kind of laws at the global level is to bring it to the treaty bodies. So like the CEDAW Committee, the Human Rights Committee, Committee on the Rights of the Child, even the Committee Against Torture we've gone to before, with examples and stories of these laws to get them to really question the governments that come before them and are presenting their reports on how they're complying with that treaty. And of course, you can't comply with any of those treaties if you still have one of those laws on your books that actually promotes violence against women and girls. And I think just on a related point, I'll say that when there's a lack of a law, that can also be a form of discrimination against women and girls. So for example, we still see that there are a number of countries that don't have specific crimes against female genital mutilation. And where that exists, then the prevalence is fairly high. So that's also another aspect of not just eliminating discriminatory laws, but actually getting good and effective ones in place and then of course implemented.
Thank you, Antonia. Melissa, there is a question for you as well from the Philippines. Colleagues were wondering what is the opinion of the panelists and yours in particular on the fact that it takes a long time in lawmaking processes to change laws that discriminate against women. So in your experience of working with governments, parliaments, and other constituencies, is there a way to speed up this process, and what's the best avenue to engage the various constituencies in a more rapid way, since it seems to be taking so long?
Thank you, Ilaria, and thank you for the question, whoever posed it. I think this is an excellent question and is one of the, in a way it's a challenge, but I think the fact that law reform does take so much, not only time, but resources. At the end of the day, the amount of resources that are needed to actually bring about comprehensive legislation is quite enormous, beyond the means of any one particular individual or organization. But what can really help accelerate the process, I believe, is, and what I've seen based on what we've witnessed, is, for example, very strong collaboration between key government actors in concerned ministries, for example, and then also civil society who are very knowledgeable about the issues, who have studied, who have some of the evidence, and who are also in a position to propose what is needed. The collaboration between the two. I've witnessed situations where sometimes you have a very cooperative government, and because of a pre-existing relationship, there is trust with civil society actors, and they will actually engage more deeply and allow them to do the writing, drafting, and then someone will take it forward. Even where that does not exist at the outset, law reform takes a long time, but it's a process of engagement through which I think the learning and the capacity of different parties can also be built. So in that sense, I think it can be seen as an opportunity. I think the key is also to ensure that implementation, or to increase the likelihood of implementation, is to, for example, if you're working on a health law, not only work with the Ministry of Health and of course the Ministry of Law and Justice, but the Ministry of Finance has to be brought in early. There has to be engagement. So really taking a multidisciplinary approach. And in fact, that can help address certain hurdles in advance so that they don't delay the process later. So that kind of broad engagement is also really important. I think in contexts where law reform has emerged after there's been a court decision, so a mandate from a court to, for example, the legislature, that has also really helped, because those court decisions often quite specifically say that this is a problem that has to be addressed, and the rationale, the premise is also there. So in situations like that, I think having a court decision, so the use of strategic litigation even to bring about law reform. So thinking about law reform as part of a, recognizing that it's a long-term strategy, and also treating it as one of several strategies that must be undertaken, I think can help at least enrich its content. As a working group, we have actually published a thematic report where we looked at promising practices. And when we looked at law reform in particular, we said law reform can be, you have to judge, you have to look at law reform from three perspectives. For example, the process that was put in place. And I think Elise mentioned earlier the importance of participation, representation, voice, etc. That is critical. And then the substantive aspect, ensuring compliance with, for example, constitutional law, international standards, and then also the implementation part of it. Is it being financed? Are there barriers? Are barriers being removed? So looking at law reform holistically, I think is also really important. And that's what, and any process that sort of looks at all three is a more promising process, but it is a long-term strategy.
Thank you. Thank you, Melissa. And Leslie Ann, we have a question for you from Musiani from Zambia, which follows a little bit the discussion of implementation. So Musiani is asking that many of the speakers have highlighted the fact that while many jurisdictions have successfully enacted laws to safeguard gender rights, implementation of and execution of judicial decisions has not been so successful. So what can we do to improve execution of judicial decisions on eliminating a discriminatory process, or on any other issue having to do with women's rights?
Yeah. I think one of the previous speakers has alluded to this, but I think the most important is to have a constant body or a constant group of women who pay attention to this field and who actually keep, tab and can actually go and hold the state to account for implementation. But I think there is at the procedural level, I think Elisa spoke about this. This is where, the things fall apart, because you can have all the guidelines, you can have, the standard operating procedures given to the state authorities, but they fail their due diligence in that they don't follow through on all of this. So it's not, there's no singular answer to this, but I think what we've come to understand over time is that this is a work that has to be, we have to keep the ball in the air all the time and be working at it. I think when we part of, I'm part of the South African Women Lawyers Association, part of what we do is monitor what actually happens and hold people to account within that body if it's women. But we've also worked to have people removed where they have failed to follow through on what they were expected to do. So we also have institutions that are set up to follow through on that. And that's all work of the women's movement, getting these institutions in place. But as I said earlier on, you can have all those mechanisms in place, but you will find that there are still challenges and obstacles to that because of a lack of political will. So part of the biggest problem we have is to find and to work with political will of all state agents to get them to follow through. But it's a challenging area of work. I think all over the world we've seen that this is a big problem, and it's certainly so in across Africa. South Africa at the moment has got the strongest political will it's ever had, but it's under threat. So you win some, you lose some constantly, and the activism has to continue. Thank you.
Thank you so much, Leslie Ann. We're coming to really the close of our panel and of our discussion today. So let me conclude, first of all, by thanking all participants, all of our speakers, our panel, our special speakers, our the Deputy Executive Director of UN Women, the Director General of IDLO. It has been a wonderful event. IDLO, UN Women will continue to work on eliminating discriminatory laws globally, but we are encouraged by this discussion where we see so many women working together to achieve the same objective. So this is challenging, but at the same time encouraging, and it shows great hope, but it gives us also great motivation to continue our mission. So I wanted to leave you with this message of hope, of motivation, of capacity to overcome the challenges that are still there, and for us to continue to push back against the backlash that we are seeing on human rights and women's rights in particular. A message of solidarity to all women who are in emergency situation, in war conflicts, all of our solidarity. And with that, I would like to thank everyone, especially our audience. The chat is still very active. Thank you so much for keeping the discussion alive. Thank you, colleagues at UN Women and IDLO, and wishing you all a very happy International Women's Day and Women's Month, and see you next time on the next webinar. Thank you again, and goodbye, everyone.